The court is now back in session. We would like to hand over to counsel for Mr. Kyo Sampon to make some observation or comments in response to the key documents presented by the co-prosecutors and lead co-lawyers for the civil parties during the hearing on the 24th to the 27th of June. You may proceed, counsel, again.
Thank you, Mr. President. Just before resuming my response to the application made by the co-prosecutors regarding the admissibility of D366/7.1.366, I wish to clarify a point that I raised twice this morning that can be rendered even clearer regarding the applications that we have submitted. This morning I referred to only one single request, which is why it could have led to ambiguity. This was the two requests concerning the admissibility of a book written by a former co-investigating judge of this tribunal. To be utterly clear, we submitted a first request prior to the hearing of the release on bail of Mr. Kyo Sampon. The request was dismissed on the 11th of April 2013 on the basis that the request was made belatedly. That is, just prior to the hearing schedules for the release on bail of Mr. Kyo Sampon. The second request to tender into evidence Mr. Marcel Lemonde's book was an application reasoned by the potential of this book to discuss, debate, and assess the probative value of evidence into this trial. The document I am referring to is E280. And that particular application has not been dismissed, but Annex 4, that involves a table that we have conveyed to the senior legal officer, states that the Chamber intends to reject our request on the basis that it is void of any relevance. Yet, to this day, we have received no further information. And that, Your Honors, is the first clarification that I deemed important to raise before you, as there seemed to be an impression that our team had only submitted one single request. I shall now resume my presentation where I left off just prior to the lunch break and address the criteria of admissibility as pursuant to Rule 87.4. Based on our reading of this provision, any requests made pursuant to this rule must not only be reasoned, but it also must show that all due diligence was exercised and that the document fulfills all criteria of admissibility as outlined in Internal Rule 87.4. In the absence of due diligence, or in the absence of the exercise of due diligence, as I stated this morning, the few lines with which the co-prosecutors had justified their request before this chamber, the only reason that we were able to extract from their explanation that the document would help ascertain justice was not made evident. We were not given any reasons why. And at no time whatsoever did the co-prosecutors explain how they actually discovered the said document. Was the document revealed earlier with the practice of all due diligence required? That is what your chamber must determine based on the rule that your honors have prescribed, as well as in your decision E290 under paragraphs 22 and 23, according to which the party making the request must demonstrate before the chamber that all admissibility criteria have been fulfilled and that it was impossible for them to practice due diligence prior to the start of proceedings. Therefore, there may be a few exceptions to this requirement as required by the administration of justice or other documents that have already been admitted into evidence and with which there is a close relationship. This is in paragraph 32 of E290. Nevertheless, the request of the co-prosecutors does not square with this particular predicament that has been drawn out by the trial chamber, and therefore no exception could be made. Indeed, the co-prosecutors had knowledge of the existence of the Kendall report well before the start of the hearings on key documents, well before the proceedings that took place during the week of June 2013, from the 24th to the 27th of June. In May 2010, or rather, even as early as February 2010, the co-prosecutors asked the co-investigating judges in document D260 to admit into evidence this particular document. And it was on the 4th of May. This request was made more than 3 years ago.
Les procureurs n'ont pas non plus
The co-prosecutors failed to provide an explanation as to why this document was not on their initial list, as pursuant to the internal rule, with the filing in April 2011 under 80. And with respect to key documents on joint criminal enterprise, the request was made by the co-prosecutors. This is just clear demonstration that there was a clear and unequivocal absence of due diligence on the part of the co-prosecutors. I question as to whether this document is admissible under Rule 87.3, which stipulates that a document shall not be admitted if it is of a repetitive nature or if it is unlikely to demonstrate what it seeks to, what it purports to prove. I wish to emphasize that, firstly, the said document is a mere scan. What I mean is that the document is an electronic photocopy. There's absolutely no possibility to verify its authenticity or reliability. It is reputitious. In the co-prosecutor's request, they cited that it may contain some examples of executions, forced transfer, as well as accounts from refugees. I am of the opinion that your chamber has already heard an ample amount of refugee accounts in order to consider that this document is, in effect, repetitious. In conclusion, I wish to point out that this document contains subjective and biased information. It comes from a security entity, a security organization from the United States, opining on what happened in Cambodia before April 1975. This document does not contain an objective and impartial analysis of the facts. The organization that produced the document had very clear interest in exhibiting its own version of the events or disseminating its own reading of the events. I can cite that the report says that the American bombings took place with the support of Norodom Sihanouk. The report also denies that the Americans had not participated in the deposition of Prince Sihanouk in support of the Lon Nol government. This particular telegram or this particular document had been drafted by an officer who worked for the National Security Council of the United States in a context of armed conflict. The United States was heavily involved in the armed conflict with General Lon Nol. And the author of the document has not been summoned to testify before this court. I therefore believe that it is entirely reason to say that this document brings absolutely nothing to these proceedings, since the sources it cites on the crimes committed by the Khmer Rouge are unknown. It is a document that merely lifts refugee accounts, media clippings, and reports. Therefore, for all of those reasons, we respectfully request your chamber to dismiss the request of the co-prosecutors to admit into evidence document D366/7.1.366. The microphone seemed to turn itself off. I wish now to raise an additional point concerning the 5 policies that have been commonly referred to in the closing order as policies that were implemented by the Khmer Rouge between 1975 to 1979. After having seen the transcripts of the hearing on key documents, as well as the statements made by the civil parties, there are actually many more policies at issue. And that were defined as such during the key documents hearing in June. Although I will not be addressing those. Following your decision, this trial has been severed into a multitude of trials, and those trials serve to try facts and crimes that are outlined in the closing order: forced transfer, as well as the treatment of former officials of the Khmer Republic. Based on our analysis of what has occurred, what has unfolded, and since your decision, and I know that I am not alone in considering this, since your chamber issued its severance order, it has been difficult to establish the criteria as well as the exact contours of this first trial. I refer now to policies that do not fall within the scope of this first trial, that is the establishment of cooperatives and forced labor camps, the treatment of enemies from within and abroad, the treatment of the Vietnamese, the Cham, the Buddhists, as well as the regulation of marriage. The reason why the trial chamber has not provided all of the legal certainty that we are entitled to, in my mind, reposes on the fact that there are problems that emanate from your decision to sever this case and to deal only in this first trial with modes of responsibility, that is to say, joint criminal enterprise, and the legal uncertainty also manifests in the successive applications made by the co-prosecutor's office in order to broaden the scope of this trial. The Supreme Court had undertaken an analysis. The debate was rather progressive.
The President Council, could you please hold on, and Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. I rise to object to my friend's submissions which have nothing to do with document presentations or a response to our document presentations for the same reasons that Councillor Sonoruan was directed this morning to refrain from these submissions. We invite Your Honours to issue the same direction to Mr. Virkin. The purpose of these hearings, as we understand them, is to deal with documents and respond to give the accused an opportunity to respond on the documents we've presented. My learned friends is veering into issues of alleged uncertainties as to scope of trial, which submissions with which we disagree. I'm not going to make submissions on that because I object to my friend dealing with them, other than to note that from the very severance order itself in September 2011 onwards, the scope of the trial has been clearly delineated, both in relation to paragraphs of the closing order and specifically in relation to topics. But I do object to my friend dealing with these issues at this point. They've been adjudicated. They are the subject of an appeal before the Supreme Court, and they're not the purpose and the subject of these hearings.
The objection lodged by the co-prosecutor provides me with the opportunity to point out a further uncertainty, which has been our uncertainty as we have endeavored to prepare for the proceedings on key documents. It is an uncertainty that is defined by the fact that the Khieu Samphan defense team must raise this today. I would make two of the following references. And the first, Mr. President, is yours. At the opening of this hearing, you stated that we would have the right of reply to the key documents that had been presented some 2 weeks ago by the co-prosecutors as well as by the civil parties. And there's a second reference that I believe must be understood in a broader context, and I refer to your memo. E288/1/1 from the 17th of June, in paragraph 6, in which you state, and I quote, "The Chamber subscribes to this decision and will allocate a half-day to the Kyosampan defense team during the key documents proceedings in order to present their objections to the key documents presented by the other parties during that week of hearings." And this is exactly what you have said at the start of this afternoon's session, in order to address all other documentary evidence regarding the accused Kyosampan. I do not seek to raise a dispute. I do not seek to serve as a bad example to more junior colleagues and lawyers in this courtroom. But what is my role in this courtroom today? Because ultimately, I am at a loss.